We have a quorum, and this is the appointed time. Let's invite the administration to join us. Well, there was a meeting on the 12th of July. That was the only meeting, and this is the second meeting. Last time there were questions raised. They are related to depositing activities on the ground and what constitutes an offense, so on and so forth. We will wait for the administration to come in to hear their responses. Well, perhaps we will now deal with the public hearing. Do you think there is a need for one? Let's have one, because there may be views from dump truck drivers or from affected residents. Yes, especially people in the new territories, people who have their fish ponds filled up. Let's set the time. There are 2 available slots. Albert, we're talking about a public hearing. There are 2 available dates. One, the 29th of October, which is a Tuesday at 10:45. The other one is 4th of November, which is a Monday, also 10:45. of October, a Tuesday at 10:45. Or the 4th, well, I'm not available on the 4th at 10:45. I don't think Mr. Chan is available because it's about the copyright bills hearing. Perhaps we'll set it on the 29th. The Secretariat will give you reply slips. There are only 8 members, me included. If the 4 of us have decided on the date, I ask you all, myself included, to attend. I now ask the administration to give us the reply to questions raised on the last occasion. Paper number CB bracket 11853/12 to 13 bracket 01. Let's go through the paper one part after another instead of doing it in one go. First, part 1A. Albert? In relation to the 3 issues raised, first, in relation to related legislation, those related to fly tipping of waste, there are 7 pieces of legislation. Those under the Environmental Protection Department and those under other departments. This is for information only. In relation to fly tipping of waste, and very often different ordinances were invoked. As you may be aware, in recent years there is a mechanism under which the EPD will coordinate in cases of fly tipping of waste. Different departments will take action under the coordination of the EPD. So you have listed out all the related legislation, right? Or 1,800 or so. We can't do it ourselves because we are not sure that we will be able to come up with an exhaustive list. Can we get an confirmation from the Department of Justice? The information comes from a follow-up question of a similar issue. The relevant department explained to members where it involves fly tipping of waste. It will be difficult to list out all ordinances. But you see in this information here, it covers all the departments that are involved. So they're more or less all there. If your researchers, the researchers from the different political parties have found ordinances that are not listed here, then please give us the information. Mr. Lee Chuk-yan, I don't know whether that's all of it, but one of them is very important. It's related to cases I've handled. It's under 2.2 Town Planning Ordinance. Why do we need this amendment? It's because the ordinance under 2 Town Planning Ordinance is not effective. How many cases were there involving the planning department against an unauthorized filling? And very often, when prosecution action is taken, the filling has already been completed. So destruction has already occurred. So we need this piece of legislation because the enforcement action of the planning department has proved to be ineffective. Do you have the information with you? We don't have the figures with the TPO or the town or the planning department. The main purpose of this amendment is in relation to the waste disposal ordinance, that is the one under the EPD. The main points are the notification procedure and also the reporting procedure and also application and to get permission. And this will improve enforcement effectiveness. Well, perhaps we can get some information from the planning department. We need to see if this amendment will be able to plug all the loopholes. Other members. Mr. Lai. This was one of the follow-up measures from a similar bill last year. Members have expressed concern in relation to destruction first, developed later. The planning department has tightened up the relevant measures in 2011. From the information I have, after they have tightened the vetting procedure, they have considered 30 suspected destruction first, development later cases. So in the end, 6 cases were approved and 20 rejected and 4 deferred. After the measures were tightened, and this has reduced an incentive to engage in fly tipping. I want to ask, out of the 7 ordinances, are there any ones that regulate rural areas? Any covering both urban and rural areas? Because there were questions asked in this relation on the last occasion. Most of them are related to a majority area of Hong Kong, apart from the country park ordinance. And it's not targeting a particular area in the rural area. It's territory-wide. And in relation to drainage, perhaps it's more to do with rural areas. Because it's in relation to small-scale drainage system. Well, I asked this question because They may not be legalistic ordinances. Say, for example, just a private street in Mongkok. Is it covered by any particular ordinance? Any ordinance that covers that, and areas in the new territories? Any one of them that does not cover the urban area? Just well, there is no particular one that targets just the urban area or the rural area.
From the town planning's point of view, well, they do it from the perspective of town planning and FEHD from the perspective of environmental hygiene. Regarding a private street in Mongkok, for instance, well, it depends on the enforcement agencies. If it is an environmental hygiene nuisance, then whether it be in the rural area or in the urban area, that ordinance can be invoked. But for land drainage ordinance, for instance, the problem may be more common in the rural areas than in the urban areas. But there is no particular ordinance here that applies only to the urban or rural area in particular. So, for instance, what about private lots in the country park ordinance? Perhaps this is the clearest among the different pieces of legislation. Any follow-up, please? Mr. Lee Chuk-yen would like to have enforcement statistics under the town planning ordinance. So administration or department, please give us the statistics later, okay? Part B, the 20 square meters of permitted area. Last time members asked why you only consider two-dimensional restriction, just 20 square meters. What about the area above or below the ground? Perhaps people would dig a big hole and dump construction waste into the pit. Perhaps the administration should consider imposing stricter restrictions. Yes, we'll talk about 20 square meters of permitted area. We will consider the enforcement situation and past experience. And after a review of such factors, we believe the current proposal is easier to enforce and would avoid disputes. Any question on this point? Before the meeting started, well, we talked about a dump truck fly tipping. Now, at landfill, if the waste is dumped at landfill, then the load cannot be, or rather, the mass could not be too much. But if it is fly tipping, it's different. Well, I believe they need the consent of the owner before hoarding and fencing can be erected to increase the height of the lump. Members may move an amendment to this point. So, DOJ, please reconsider this point. C is about whether reinstatement is required under the ordinance. Under the waste disposal chemical waste general regulation, we do have such a requirement that is under Cap 354C section 31 for disposal of chemical waste. And under the town planning ordinance, section 23(1) and section 23(3) have similar requirements on reinstatement back to the condition before fly tipping. So, drawing reference to these two requirements, we have followed them in the proposed bill, and we have not added additional requirements. When Disneyland was built, there was a shipyard where land was contaminated. And for whatever reasons, chemical waste was found, and then great efforts were made to clean up the land. Now, if similar things happen again, it will be for the Director of Environmental Protection to be satisfied that the waste has been removed or dealt with. Satisfy. What do you mean by satisfy? Do you mean that the Director is satisfied that the land has been properly cleaned up? Yes. Mr. Wong from the Enforcement Department. Under the chemical waste regulation, if there is chemical waste that has to be dealt with, then for every batch of the contaminated chemical waste or land to soil to be removed, licensed chemical waste collector has to be commissioned to do it, and the contractor is required to transfer the waste to a specified site, and it is either one of our landfills or the chemical waste treatment center at Tsingyi. Each truck has to keep proper records of receipt and disposal. So we will first assess the amount of such chemical waste at a particular site, and after the waste is transported away, we will check the records to ensure that the volume and the transportation and the final destination of the waste are consistent with the requirements. Though this is not really a special requirement, all chemical waste has to follow this routine arrangement. Well, going back to my example, I think it was Choi Lee Shipyard. Because of shipbuilding activities, there was chemical waste seeped into the soil. Of course, construction waste will not contaminate the soil, but for other kinds of waste, if there is no proper precaution taken, I'd like to know whether you're able to deal with such scenarios. Well, it all depends on the waste, type of waste you're talking about. I think, Chairman, you're concerned as to whether fly tipping will cause contamination of soil. Well, if the case is established, we will ask the person responsible to deal with it, because the regulation requires such waste to be properly transported and disposed of. For construction waste, our concern might be asbestos, which is a solid waste. So the packaging and also transportation have to be done carefully. And once this is thoroughly done, the original site should not have any residual environmental problem. Any follow-up, please? If not, we go on to the issues raised by our legal advisor. We'll go through the questions and answers one by one again. Okay? Page 3 of the paper, part 2. First question by the legal advisor. The first question from the legal advisor is the commencement arrangement. As explained in the paper, we will allow some time for the affected stakeholders to be informed and the commencement date will be announced by Gazette. There will be a few months in between, and the commencement notice will be subject to negative vetting by the Council. Well, we've recently found that some pieces of legislation have not come into operation after they've been enacted for a long time. So will the DOJ inform the Council from time to time, perhaps through a quarterly report, when some pieces of legislation will come into operation? And I believe the latest decision is to follow up with the administration at the House Committee. DOJ, I may not be able to answer this question on behalf of the department, but there is an internal record kept by the administration regarding ordinances enacted but not yet commenced. How many items have you got on the list? A few dozens? Regarding the chairman's question, I'm afraid I cannot answer on behalf of the DOJ. I think you have to pursue on another occasion. Yes, for members' information. Recently, there's a case involving compensation. The law has been passed but not yet commenced. So there is a compensation problem, and such matters will be dealt with by the House Committee. Well, since this is just a very minor amendment, I hope you can have it commenced as soon as possible after enactment. All right, second question, definitions. Now, the land has to be held under government lease, and then there must be a lot number assigned to the land. And the legal advisor has asked 3 questions. First, whether there is any land held under a government lease without identified by a lot number. And B, whether there is any land identified by a lot number but not held under the government lease. And C, whether any site is there any site held neither under a government lease nor identified by a lot number. And in fact, the definition is quite wide. It can really include short-term tenancy leases. However, these STD cases do not suffer from the same enforcement problem. The legislative intent is to tackle private land where the landowner is not traceable. Still, such lease is held by the government, and therefore these cases are not targeted under the bill. So we have not particularly targeted at such cases. Category 2, whether there is any case of land that is identified by a lot number but not held under a government lease. We've checked with the land registry and the lands department, and there is no such case. 3, whether there are lands not held under a government lease and do not have a lot number. Yes, there are such examples, but they are very unique. For instance, we've got land vested in a person by an ordinance such as the Kowloon Canton Railway Corporation, and as well as the St. John's Cathedral Church in Central. However, these cases, again, do not suffer from the same enforcement problem that the bill aims to tackle, and hence they are not covered under the bill. We do not have specific provisions to tackle such cases.
So, well, if it is not covered by the legislation, then it will be meaningless. But even if it is covered by this, that can be enforcement action taken under 16A. Say, for example, for Category 3, land vested in the KCR Corporation, well, that there is a designated landowner, unlike land in the new territories when owners are difficult to identify. So, and there is no depositing problems in relation to these sites. Mr. Wu Chi-wei, in relation to part 3 of this answer, if it's not land held under a government lease, nor is it under the KCRC or the Church of England, will there be a list of owners? Say, for example, a list on the registry? Well, I just try to ask the question in a different way to get clarification. Well, whether it is at the Lands Department or the Lands Registry, when there are approvals given in relation to private lot, the Lands Department will issue a document or an instrument which will then be deposited with the Lands Registry, and then a lot number will be issued. So in relation to private lots, there will be a lease. The lease information include to whom is given and the boundary of the lot, as well as other conditions. So in relation to the identity of the owner, the information will be can be found. And as soon as the lease is given to the land registry, a lot number will be given or assigned. As far as we understand, when it comes to sites in the new territories, it may straddle between a private lot and government land. If there is waste deposited covering both sites, of course, when it comes to government land, there will be law enforcement action. And for those on the private lot, they will have to find out whether there is consent from the landowner to see if the depositing activity are covered by an approval. So if half of the waste covers government land, the other private land, then on the whole is illegal. Is that right? If it covers both private land and government land, for the areas that are government land, we can use Section 16A. And in relation to private lot, of course, 16A is applicable. And as to whether 16B is applicable, we have to consider whether it's bigger than 20 square meters. Or if it is under relevant or related depositing activities in the schedule. But let's say if it touches government land, then we can take enforcement action against 16A. For private law, we will consider whether we can use 16B. If it's applicable, then we will seek advice from the DOJ to see whether we should use A or B. On a private lot, if it is smaller than 20 square meters, they can get away with it, right? The way 16A is written is that there is no exemption. Under 16A, under 16B, any waste deposited will have to be covered by consent or permission from landowner or occupier. And the government will find out whether there is such permission or consent given. I see that in paragraph 9, but we're going through it part by part. So question 2, any follow-up? Legal advisor, are you happy with the answer? Question 3, perhaps we will ask the official to explain first. Well, this is related to the following questions as well. That is, if there is or are structures on the private lot. When we're drafting this bill, we have in mind cases in which there has been depositing activity. If there are structures on the piece of land, waste deposited inside the structure is not covered by 16B, because that is not the general fly tipping of waste we see. Well, those are usually done by dump trucks, and inside the building, people will just take the waste up. So it's not covered by this bill. Mr. Wu. Paragraph 9. Well, what I have in mind is abandoned structures in New Territories villages. So, if I am minded to deposit waste, as long as I do it inside a building on the lot, that will be all right. So what if half of the structures has collapsed? This is of the same nature as digging a hole or a pit. There are many different cases, but when we draft the bill, we target the general practice of depositing activities. Usually it involves a dump truck just dumping the waste on the land, and then they would leave. And when it comes to digging a pit, if they are willing to incur the huge cost in digging the pit, then they would rather pay $27 per ton to dispose of the waste properly. And if they are to do it inside a structure, they'll have to do it perhaps barrel by barrel, and it is very costly and time-consuming. Sometimes when we go to Sai Kung, we walk past abandoned houses in villages. Yes, if there is a proper door, you have to just wheel in the waste barrel by barrel. What if the general structure has collapsed? Well, then we have to consider each case on its own, and we will seek advice from the Department of Justice. Yes, we understand that the general practice is not like this. But we're talking about abandoned or old villages. There are developments taking place in these villages. So if there is works, but instead of having to transport the waste away, they can simply dump it next door. Of course, what the director has in mind is just the general practice using dump trucks. You rely on the owner to protect themselves, but we're talking about abandoned villages. The owners may be overseas. I just wonder whether there is any way the government can help. We're talking about abandoned villages. They may not be right next to a vehicular access, and they may be next to a path. Dump trucks cannot directly reach the site. But still, what Mr. Wu said is possible. They can simply dump the waste next door. Please take this into consideration, because that is perfectly possible. Mr. Lee Chuk-yan, a similar question. Of course, when it comes to the usual cases of fly tipping or destruction first and development later, that is on a piece of land. But if you go to an abandoned village, Well, the definition of a structure is not clear. Perhaps there is just some tiles, a short structure, a bench without a roof, so it will be very easy to dump the waste in there. We're not worried about cases involving a proper building or a house. There may not be many cases in the past, but this is a loophole, and we are aware of it, so we may as well plug it. Talking about a piece or parcel of land, it may include some dilapidated structure. Could you plug the loophole? There are many such structures inside Pak Tam Chung, the restricted area in Sai Kung. You can see the shape of a house, but the walls are only waist high. Legal advisor, I have a question for the administration. In relation to definition of a private lot and also section 16B1A, what about the boundary? You said a piece or parcel of land, but it doesn't mean that it's an open area without any structure on top. Perhaps I will take this question. I thank the legal advisor for her question. Well, we can deal with this in two ways when it comes to the definition. That is, well, the definition is that it is held under a government lease, and the boundary is the one designated on the lease, by the lot. So first we will look at the lease, we look at the boundary of the lot, and then if there are structures, the structures will be excluded. You have to refer to 16B3. That is the offense provision itself, that any person depositing any items on a private land is against the law, and it depends on whether it is a piece or parcel. So if it is done within a structure, we don't think, and this is depositing activity done on a piece or parcel of land. Legal advisor. Well, yes, you can see the. Will you be able to see the piece or parcel of land on the lease? The lease may include a huge piece of land. So the private lot may include one with a structure or one without. Well, there are two parts. First, the boundary, and the second part, whether the depositing is done on a piece or parcel of land. But I failed to see 16B brackets 3 and 16B bracket 1A. There is an exclusion, that is 20 square meters. It says that does not exceed 20 square meters in a lot. So there may be some structures there, and you said that there is a minimum area of 20 square meters, and you're referring to just open space. Under waste disposal ordinance, there are other provisions. When it's applicable to a structure, it will be specified. Say, for example, in Buildings Ordinance, Section 13. building land. Building or land. So Section 3 will specify the building. Section 16 is the same. Land or premises. So if it refers to premises, then it will be specified. And Section 20A is something similar.
21 capital A says land or premises. So under the waste disposal ordinance, the provisions will specify whether they apply to land or premises. So do you have to cross-reference it here? Well, there is no need to do so, because that is the mode of construction in the whole ordinance. Can the administration give us a written, give us a paper to set out the arguments? If my understanding is correct, Mr. C is talking about the buildings ordinance, no, rather the waste disposal ordinance. So please give us a paper on this. I think there's a difference between the legislative intent and the technical details. According to the DOJ, if the provision means building or premises, then it will be specified. And here, because it says land, that means buildings are not, or structures are not covered. And other legal point is whether it is possible not to include buildings. For instance, for a 3-story village house, of course, it's unlikely that you carry the waste all the way up the floors. But what if it is a dilapidated building? Is it still regarded as a building or premises? If there is no distinction between land and a building or premises, then we are more assured, because we don't know how dilapidated a building has to become before it is no longer a building and become part of the land. Or we will say that so long as there is a tile or a brick on the ground, it is still regarded as a building. So please come back and tell us again. Of course, Mr. Lai said that it was rare for construction waste to be dumped inside a house. But sometimes it's hard to say. On agricultural land, there might be a small hut or a small house, and it is used for dumping as well. So can you go back and check or consider whether it is a loophole to be plugged? Using your definition, then a very dilapidated structure will be excluded, and you have to amend the law in order to cover it. Now, if it is your legislative intent not to cover such buildings anyway, that's a separate issue. So please confirm whether it is your legislative intent to cover these houses. Well, we don't have a Section 13 or 16 or 21 capital letter A here. So Mr. Z, please go and check whether you have provisions to cover very dilapidated buildings and whether they should be so regarded under the ordinance. And the DOJ and also the Bureau, please give us a reply in writing. Yes, please go on. Question 4. Is how we define the boundary of a private lot. My reply is, in the government lease, there is such information. And we can also use standing surveying methods to confirm the boundary. Any question on this? No? Question 5. This is related to question 5, whether or how the section will apply if there is a structure on a private lot. And following our previous reply, our policy intent is to cover land only, but not any structure on the land. But if members would like us to reconsider this point, we can give you a paper later in response. Good. 5. Question 6, I mean. Also a similar issue. All right. Do we have any follow-up questions for questions 4, 5, 6? If not, we go on to question 7. Chairman. Question 7 is about persons are required to give permission. We require permission from all owners of the lot. If there are 3 owners, then permission from all 3 owners are required. And there's the issue of when the lot is owned by 2 persons who are married couples. We do not make a distinction in the ordinance, so separate permission is still required. But what if one has immigrated, is overseas, then his consent is still required. True. So this can plug the loophole of family members using the site for fly tipping when one member is not in town and they are fighting for the estate. What about land owned by Zhou or Tong? Do they have an officer responsible or general manager of a Zhou or Tong land? The owner can be a natural person or a body corporate. So Zhou or Tong is a body corporate. And it depends on the operation of the Zhou or Tong concerned. And if the Zhou or Tong has decided to grant permission, then permission is acceptable. Perhaps I invite the legal advisor to explain the rationale behind question 8, because we might not be too sure about the reasons for that. All right, 16B is an enhanced provision, and under section 16A there is already an offense if an offense or an act can be caught by both section 16A and 16B, how will the administration deal with it? We will submit all evidence gathered to the DOJ and, subject to the view of the department, make a decision on prosecution. And how would the DOJ deal with it? The question is, the same offense can be pursued under 2 different sections. One is stricter, the other one is not so strict. Well, this is about principles of criminal prosecution. I might not be the most appropriate person to answer this question. But a simple reply is, when the case comes to the prosecution division, the lawyer will decide which offense is more appropriate. And 16 capital letter A and 16 capital letter B, well, they have the same penalties. I can only say that the elements are different under the 2 sections. So when the case is in front of a government lawyer of the prosecution division, he will decide which section will give a greater chance of conviction. Well, you have got cases involving Section 16 capital A. Can you give us the information? And with 16 capital B added, will an offense be caught by both provisions? Well, 16A is about a person, is about consent to be given by the owner or occupier of a land, another for waste to be disposed there. 16B is about private land, and permission has to be granted by all owners. The occupier is not qualified to give permission, and there are written procedures to follow. It is more cumbersome for the factors under 16B to be satisfied. So if a construction waste is dumped on private land, both 16A and 16B are relevant. However, the scope of 16A is wider. However, the requirement on permission is not so strict. 16B is more restrictive, but the requirement on permission is stricter. According to our legal advisor, a single act may breach both provisions. Can the Bureau give us an example, a single act, and the elements for conviction under two different sections, and tell us the considerations by the DFJ when the decision on prosecution is made? I am grateful to Mr. C for telling us the penalty under both sections are just the same. This is different from assault against the police because the DFJ can choose whether to prosecute someone for use for assaulting the police with a weapon or just a minor scuffling. So please give us a case to illustrate. We are worried that the department is given the freedom to choose. If you tell us the elements under the two sections, and if they are clear enough, then we can be assured. Question 9. This is about Section 16C4. That is before a depositing activity can be carried out. The depositor has to display the part of the acknowledged form. If this step is omitted, the depositor commits an offense. And the question is, why only this is imposed on a person who deposits construction waste, but not the one who causes to be deposited construction waste? Because the depositor will be the most direct person to display the acknowledged form, and we believe this requirement is already sufficient. Now, when we go through the bill clause by clause, we're going to ask, what do you mean by conspicuous place, and whether there is already a definition in the current ordinance? Otherwise, we'll ask you, how do you define that? And you have to tell us when we scrutinize the bill clause by clause.
We're talking about busy land in the rural area. A sign is erected, maybe in somewhere, and he thinks that it is a conspicuous spot, whereas others do not agree. The word conspicuous is a common term used in the laws of Hong Kong. I have not done the detailed research, but as far as I know, it's very rare to find a definition of conspicuous. The court will interpret the word to leave flexibility. Yes, we know that when it comes to a business registration, it will be usually at the entrance or the reception area of a company. But when it comes to a piece of land which may be vast, the spot may be deemed conspicuous by the depositor. So you should expect questions from us. We're talking about a piece of land in the rural area. If it's an office, then yes, we have a general understanding that it will be at the reception area. Any follow-up? No? Question 10. Question 10 relates to Section 8 and the proposed amendment to be made to Section 31 under Clause 8 of the bill. That is, whether it is not intended for the new offense an offense of a strict liability. Under 16A, the nature of an offense, the offense is included in Section 31. So this is a strict liability offense. So we add that to 16B. The legal advisor mentions 16C. It is not specified to be a strict liability offense. And we're asked about the position of these offenses. 16C7 is in relation to the display of the form. When it comes to strict liability offense, it's a regulatory in nature, and such regulatory offense are strict liability offense. We would like to hear the views of members, and we can have a detailed discussion during clause by clause. There aren't too many of us here, and I would rather leave it till clause by clause. Members may express concern in this area to dump truck drivers during the public hearing and hear from them. I will ask the legal advisor to give us her views so that we will have time to consider it. My view is that if it is a strict liability offense and there is a Section 31, then it should be specified to be the case under Section 31. That it should be specified that this is also a strict liability offense, because the rest have been specified. And if this also is one, then it should be specified too. Is that clear? Question 11. This is in relation to seriousness of offense. 16C6 and 7. 16C7 is in relation to the display of form. 16C6 is in relation to furnishing false information or incorrect information. The fine is set at level 6. The penalty level may be the same, but the offenses are different in nature. We draw the conclusion that penalty set at level 6 is appropriate, taking into account the seriousness and the nature of the offense. The maximum penalty at level 6 is $100,000. Question 12. It's in relation to 16C7, that is the display of the public notice or the form. It explains why a daily default fine is not included. The display of the form is to furnish information to the public. The continuous failure to display the form will not add to the environmental impact, so it will not result in a daily default fine. Do you agree with the explanation? Okay. Mr. Lee Chak-yan, I want to ask some other questions. Let's draw reference from the Ho Xiangheng case. Well, the waste covered a large piece of land, and there were police officers there, but they did not do anything to stop it, or could not. If there was no application for permission or approval and no form is displayed, can the police stop them with the activity instead of having to wait till everything is completed? But if the people are unhappy, if the police do not do anything when it's blatantly against the law, what is done? So if a form is not displayed, can the police stop the activity immediately, or do they have to call the EPD to stop the activity? Who is to take the enforcement action when a form is not displayed? I don't want to wait till it's finished before prosecution action is taken. Can they arrest anyone? I want enforcement action to be taken, not just wait till prosecution. Who is to take this question, Mr. Wong? Under the existing law, the EPD is the enforcement agency, and it's usually done by us. Yes, people usually call the police first, and the police see that there is no form displayed. Then they will have to get the EPD to come, and the EPD has the power to stop the activity. Or is it the case that the EPD has no power to stop the activity, and they have to wait till afterwards when they take a prosecution action? So I want to know how much power you have. Yes, the EPD is there, the police is there to protect you. And when there is no permission obtained, can the perpetrator be arrested? Or can the activity be interrupted or stopped? Say when there is an owner present and the owner sees that someone is depositing waste on his land, he will call the police. Will the police stop the activity immediately, or do they have to call the EPD and wait for them to arrive and then to verify that it's against the law? But the EPD has no power to use a force to stop the activity or to arrest the person, so they have to wait for the police to take the action in the end. This is something we have encountered in our line of duty. when there is illegal deposit of waste on private land. Of course, timing is important. We have to find the perpetrator. This bill helps us because we can see whether there is a form displayed, and it's a very clear sign whether permissions have been given. So this is great help to us. Of course, we have to deal with the case when the perpetrator continues. And if the perpetrator continues with the activity knowing that it is illegal, I believe that we will find ways to stop him. We'll find the responsible person. And very often drivers are just given instructions. Mr. Wong, let's come back to reality. The police is called. The police arrived without the EPD people verifying if an offense is committed. Of course, the police will not take action because they don't know about the law. And they have to call the EPD. Yes, they have to call us. So that was time lost. Well, you have the power to record the name of the driver, but the driver may not review who is behind the scene. So what else would you do? What else will you do? You don't want to prosecute just the driver. And, well, are you going to prosecute just the driver or the perpetrator that gives the instruction, or both? Well, the owner usually is just the victim, unless the owner is the one giving the instruction. Well, there is a list of questions. Can you give us the information about the process, about the steps involved in enforcement? Under 16b(3), it says a person who deposits or causes to be deposited without a valid permission, it commits an offense. This new addition helps us in cases, say, when the police is there and when the EPD officers are there. Well, currently, as things stand, it's difficult to verify whether there are permissions given. It's difficult for us to get the evidence that no permission is given. But with the amendment, we only need to look up the EPD record to see if the process have been completed. Without that, that means it's illegal. And we can also check whether there is a form. So it will be easier for us to verify whether it is illegal or not. And when it comes to a driver refusing to divulge further information, of course we have to conduct investigation. The dump trucks are very often employed in proper disposal facilities. We will be able to find traces of evidence from who employ these dump trucks in the proper facilities. And as to what would happen if the one giving instruction is the owner, all owners will have to give permission. If it's a single owner, a permission is given, what will happen? And if there are two owners, the steps are not taken, then it is illegal. So if one of them is the owner, they cannot get away with it. This is how it's enhanced. I agree that it is better because you'll be able to obtain evidence there and then.
When it comes to enforcement, I think you have to tell us clearer whether EPD officers can stop the act at once, or can you only prosecute them afterwards? Because I'm sure for such acts there would be a lot of observers, and they may accuse the EPD of being useless afterwards. I don't want to see this happen. Now, if warning is given, and if the person continues to deposit waste there, what can you do? All right. Is it easy for the police to inform you, EPD? Of course, it depends on the individual cases, but if we can decide on spot that it is indeed fly tipping, I don't think the depositor would be so daring as to continue the act when the police are present. When the act is stopped, what should be our follow-up action, then it depends on the case. I'll see whether Mr. Lai has anything to add. Perhaps it's easier for you to call the police for unauthorized trespassing of a place. Perhaps it is better. No, trespassing into private land where the person can claim that he has the consent of the owner. So it is really a headache. So how do you deal with such cases? I suggest that the Bureau and the department think about a practical case. If it happens at night, of course, usually people will carry out illegal activities at night, assuming that it is night time. What will you do? Or do you have person around the clock, manning, or do you have person on duty around the clock? Yeah, of course not. Currently, we're not. So enforcement is mainly done during normal office hours. For cases quoted just now, that is for people who are so blatant to continue the act, even if they are caught, we will carry out surprise activities, surprise operations. But usually, for such cases, they will not just leave after dumping one truck of waste. If a person is deliberately fly tipping on a private lot, then with the bill, I am sure our enforcement will be easier. If a person is really daring enough to commit an offense in front of the police, we will have regular provisions here to deal with it. For instance, obstruction of the police duty. We can prosecute a person under that provision. I need a paper on this. If you want to take enforcement action and they obstruct you, I want to be ensured that you have another provision to tackle that. Can please let us know which provision is relevant so that people know that the police or the EPD can invoke the help of the police We want our frontline officers to be given better support so that they can really do something and will not be accused of not doing anything. Obstruction of the police work. I know this is present, but what about obstructing the EPD officers to carry out their duties? Under the bill, so long as the photo and also the license plate of the car is taken, then you can take follow-up action. But members would want you to stop the act at once, so that it will not be there won't be so much hardship on the owner if he's required to clear up the scene afterwards. Because we received complaints that owners were required to clean up, although they were not the perpetrators. Any follow-up question? If not, we can call it a day earlier, because we've decided to convene a public hearing. And for the follow-up issues, we've already mentioned them. The Bureau, please give us a reply. We have already dealt with issues arising from our last meeting, and we're now going to start clause by clause. We will meet the stakeholders, the trade first, and then after we have dealt with the responses from the administration, we can start the clause by clause scrutiny. And Mr. C, if we need cross-references from other provisions, say Section 13, 16, or 21, capital A, where the term building or premises were mentioned, please let us have a list afterwards. Okay, very much. Thank you very much. Meeting adjourned.